My ex-wife demanded the holiday villa in the divorce. Not asked, demanded. She had a list and the villa was at the top of it, underlined with her attorney's handwriting beside it, nodding that this was a non-negotiable priority item and that settlement discussions could proceed once this was confirmed. Her attorney presented this to my attorney in the kind of tone that was designed to communicate that resistance would be costly and that agreeable capitulation was the sophisticated response. The judge looked at the property. He looked at the deed structure. He looked at the documentation her attorney had prepared, and he awarded her the villa. He handed her the keys. She called 3 of her friends that afternoon. They planned a celebratory weekend. She told me later, through a mutual contact who thought I should know, that she had described it as her reward for 8 years of putting up with me. She drove 5 hours to the property on a Saturday morning with 2 of her friends in the car, and wine in the cooler, and the specific energy of someone who had won something and wanted to arrive at the winning. She turned onto the property road. She drove down the long drive. She stopped the car. She sat there for a long time. The villa was not there. The foundation was not there. There was a field. Clean, flat, slightly disturbed soil where a structure had recently stood. The landscaping at the perimeter was intact. The utility connections were capped correctly. The access road was in good shape. But the house was gone. She called her attorney immediately. The attorney called my attorney. My attorney said the court awarded her the real property, the land. The villa is a structure that was registered separately as a manufactured home under state classification. It was removed from the property 6 days ago. The structure was sold. The proceeds belong to my client. Her attorney said, that is not what the judge intended. My attorney said, the order specifies the real property. The structure is not real property under the applicable classification. The order was followed precisely. There was a long silence on the call. Then her attorney said, I need to call you back. He called back 2 hours later. He said, we are going to need another hearing. My attorney said, we look forward to it. Before I tell you what happened at the second hearing, and what the judge said when he understood what had occurred, and what my ex-wife said to me the one time we spoke directly after all of it, I need to take you back to where this story actually starts. Not the divorce. Not the villa. Back to a man who built something with his own hands in the mountains of North Carolina over 3 summers, and who knew, from the first nail, exactly what he had built, and exactly what he owned, and exactly what category the law put it in. Like this video right now. Subscribe to this channel and ring the notification bell. Comment below, when I said the villa was gone, what was your first thought? Let us start from the beginning. My name is Thomas Garrett, and I am 56 years old. I grew up in Hickory, North Carolina, in a family that understood wood. My grandfather, Earl Garrett, had been a furniture maker in the days when Hickory was the furniture capital of the world, when the factories along the railroad corridor were producing chairs and tables and bedroom sets that ended up in homes across the country, and when the craft knowledge was passed from the older workers to the younger ones in the specific oral tradition of people who learned by watching and doing rather than by reading about it. Earl had retired by the time I was old enough to know him well, but he had a workshop behind his house where he still went every day, and where the smell of sawdust and linseed oil was so present and so specific that I could not smell either of those things in my adult life without being immediately back in that workshop, at 8 years old, watching his hands move across a piece of wood with the ease of someone for whom the movement had become completely automatic. He gave me my first set of tools when I was 9. A hand plane, a set of chisels, a square and a marking gauge, a pull saw. He said, these are the tools that tell you the truth. The power tools do the work faster. These ones tell you whether the work was done right. I did not fully understand that until I was much older. What I understood at 9 was that wood was real, and that working it with the right tools produced something you could see and touch, and that held its shape. My father, Carl Garrett, was a building contractor. Custom residential work across the Catawba Valley. Not the largest operation in the county, but the most respected in the specific sense of a contractor, whose clients called him back for every subsequent project, and whose name moved through referrals rather than advertisements. I worked on job sites from 14. Real work. My father had no patience for the idea that a 14-year-old on a job site was decoration. If you were there, you worked. If you did not know how to do something, you watched until you did, and then you did it. If you did it wrong, you fixed it, and then you did it right. He said, every nail you put in this house is in this house for the next 100 years. Put it in the right way. By the time I graduated high school, I had framed walls. I had set foundations. I had roofed 2 houses and sided 4 and installed windows and doors enough times that the process had moved from conscious to automatic. I went to Appalachian State in Boone for civil engineering. 4 years in the mountains of western North Carolina, with a dual track of classroom and weekend work that my father arranged through his network in the Watauga County area. I came back to Hickory in 1990 and went into my father's business as a partner, not as an employee. He said, I am not interested in having an employee who is also my son. If you come back as a partner. Full responsibility, full share of whatever we make. I came back as a partner. We built together for 12 years. My father retired in 2002, and I took over the operation entirely. Garrett Construction was not a large company. 8 to 12 employees depending on the project pipeline. Annual revenue between 2 and 4 million. Custom residential and light commercial work across a 6-county area in the western Piedmont and the foothills. I was good at it. I was good at it for the same reason my grandfather had been good at the furniture, and my father had been good at the houses. I genuinely cared whether the thing was built correctly. Not for reputation reasons, though reputation was the result. Because I had internalized, from the workshop and the job sites and 1,000 conversations with my father and grandfather, the specific conviction that a thing built correctly was a fundamentally different object than a thing built adequately. A thing built correctly lasted. A thing built adequately lasted until it did not. I chose correctly. I met my ex-wife in 2005. Her name was Diana. She was from Charlotte. She worked in marketing at a financial services company. She was energetic and social, and she had the specific quality of warmth that made everyone in a room feel like she was focused on them. We married in 2007. The first 4 years were good. The middle 2 were complicated. The last 2 were the kind of last 2 years that produced a divorce filing. I am not going to spend a great deal of time on the specifics of how the marriage failed because the marriage is not the story. What is relevant is this. By 2013, when the separation began, Diana and I had built a life together that included the house in Hickory where we lived, 2 vehicles, a modest joint investment portfolio, and a property in the mountains outside Boone that I had been building incrementally for 3 summers. The Boone property was 5 acres in Watauga County. I had bought it in 2010 for $82,000. Raw mountain land, no utilities at that time, no structure. A long road in from the county road and a clearing at the top that looked out over a ridge line that was the specific kind of view that people drove long distances to see. I had bought it because I knew what I wanted to do with it, and because the price was right, and because the land itself was the kind of land that a man who had grown up in Hickory and who had worked across the western Piedmont recognized as fundamentally valuable. What I had done on that land over 3 summers was the thing that Diana's attorney had not fully researched. The structure on the Boone property was a modular home. Specifically, it was a high-quality custom modular unit that I had designed in collaboration with a manufacturer in Lenoir, and that had been delivered to the Boone property in sections and assembled on site by a crew that included me working 3 full weekends of the first summer. I had not built it from scratch on the property. I had built it off the property in sections and had it brought to the property and assembled there. This distinction was not something I had thought about primarily in terms of future legal strategy when I made the decision. I had made the decision because modular construction for a mountain property made practical sense. The site access was limited. Carrying materials up a mountain road and doing full stick-built construction at that elevation, and in that climate, was significantly more expensive and more time-consuming than having sections built in a controlled environment and assembled on site. It was the right construction decision for the property and the use. I had registered the structure correctly under North Carolina's manufactured and modular housing statutes. The structure had a separate title from the land. The land was real property. The structure, under its registration, was titled personal property. A manufactured or modular home is, in North Carolina and in many states, classified differently from a stick-built structure when the owner chooses to maintain it as personal property rather than affixing it permanently and having it reclassified as real property. I had chosen to maintain it as personal property, not because I anticipated a divorce. Because the classification gave me flexibility, the ability to move the structure if I ever chose to sell the land and keep the building, the ability to finance the structure separately from the land if that ever became useful. These were legitimate reasons that had nothing to do with Diana. We were happily married when I registered it. When the marriage began to fail 3 years later, the classification was simply what it had been from the beginning. Diana's attorney, in preparing the divorce settlement demands, had looked at the Boone property and had seen 5 acres in Watauga County with a structure on it. He had looked at the county tax records, which showed the property and the improvements. He had looked at the insurance documents, which listed the villa and its contents. He had not looked at the title structure. He had not looked at the manufactured housing registration. He had not asked the question that would have produced the answer, which was whether the structure and the land were the same asset under the same title or 2 separate assets under 2 separate registrations. He had assumed they were the same. Assumptions in real estate were expensive. I had learned this from my father and from 20 years of building things correctly. Diana's attorney was about to learn it from my attorney. I want to be honest about when I understood the opportunity. It was not when the divorce was filed. It was not when Diana's attorney submitted the property list with the villa underlined and marked non-negotiable. It was in a conversation with my attorney, a woman named Margaret Holt, who handled my business legal work and who had agreed to represent me in the divorce proceedings, when she asked me a question that she asked about every asset on the list. She said, "The Boone property, tell me about the structure." I told her about the modular construction and the delivery and the assembly and the registration. She said, "Is the structure titled separately from the land?" I said, "Yes. The land is real property. The structure is registered as personal property under the manufactured housing statute." She was quiet for a moment. She said, "And Diana's attorney has listed the Boone property in the settlement demand." I said, "Yes." She said, referring to it as the villa. I said, "Yes, that is what we called it informally." She said, "But what he has actually described in the legal documentation is the real property." I said, "I believe so. He used the address and the parcel identifier." She said, "Which is the land?" I said, "Yes." She was quiet for a longer moment. Then she said, "Thomas, I want to look at the exact language in the settlement demand and in the registration documents before we discuss strategy. Can you bring both to me Thursday?" I brought them Thursday. She read both documents at her desk while I sat across from her. When she looked up, her expression was the expression of an attorney who has found something and who is deciding how to communicate its significance. She said, "The settlement demand describes the real property by address and parcel number. It does not describe the structure separately. The manufactured housing registration documents are distinct. The structure has a separate title document." She said, "If the court awards the real property as described, the structure is not included in that award." I said, "What does that mean practically?" She said, "It means the land transfers. The structure does not." I said, "And the structure can be moved?" She said, "It is modular, designed to be moved, yes." I said, "And I can sell it?" She said, "You can do whatever you choose to do with your personal property." We looked at each other across the desk. She said, "I want to be clear about something. What you do with the structure before any court order is issued is entirely your decision. Once a court order is issued regarding the real property, the order is what it is. There is no court order about the structure." I said, "Because no one has asked for the structure." She said, "Because no one knows the structure is separate from the land." I said, "Can you find out what the structure is worth?" She said, "I will have an appraisal done this week." The appraisal came back at $214,000. The land had been appraised at $160,000. The total property value that Diana's attorney believed he was securing for her was $374,000. What the court could actually award her was $160,000. The rest was mine to do with as I chose. I made some calls. Subscribe to this channel right now and ring the notification bell, because what I did in the week between the court order and Diana's arrival at the property is the part of this story that I want to tell you about very specifically. Section 3 is where the villa gets moved. Finding a buyer for a custom modular home that needed to be relocated was not the simplest transaction I had ever managed. But I had been in construction for 25 years, and I had a network. The buyer was a couple from Rutherford County who had land and who had been looking for an alternative to new construction that could be placed on their property, and that had the specific quality finishes that new manufactured homes at the standard price points did not typically offer. The villa had custom finishes because I had built it as a personal property and had built it with my own hands and my own standards. The couple came to see it on a Wednesday. They walked through. They were quiet for most of the walkthrough, in the specific way of people who were encountering something better than what they had expected. The woman said, "The kitchen." I said, "I installed that kitchen over a long weekend. The cabinets came from a shop in Lenoir. The countertop is local stone." She said, "And you built this to move?" I said, "I built it modular. It was designed for this." Her husband said, "What does relocation cost?" I had already gotten 3 quotes. I gave them the range. They looked at each other. The husband said, "And the price?" I said, "What I need is fair for both of us." We negotiated. We agreed on a number that afternoon. The court hearing on the divorce settlement was on a Thursday. The sale of the structure closed the following Monday. The relocation company arrived on the property on Tuesday. They spent 3 days on the disconnection and preparation. The structure left the property on Friday. 6 days before Diana got in her car with her friends and her wine and drove 5 hours to celebrate. The property when she arrived was clean. I had made sure of that. Not out of spite, because a clean property was what the land was without the structure, and I had no interest in leaving debris. The utility connections were capped. The footings were visible but level with the ground. The access road was in good condition. The ridgeline view was unchanged. 5 acres of mountain land in Watauga County, exactly as described in the court order, exactly as awarded by the judge. Just without the villa that Diana's attorney had not known, was not part of what the court had the power to award. Diana's call to her attorney from the field produced a 24-hour sequence of phone calls that Margaret described to me the following week, with the specific dry precision that she brought to everything. She said their first call was to ask if this was permitted. I said, and she said, I told them the court order awarded the real property as described. The structure was not described. It was not awarded. The relocation was lawful. She said, the second call was about the intent of the order, the argument that the judge intended the property in its complete form. I said, and she said, I pointed out that intent is not what orders say. Orders say what orders say. This order was precise about what was awarded. She said, the third call was about potential bad faith. I said, bad faith how? She said, the argument that removing the structure before she could take possession was an action designed to frustrate the intent of the settlement. She said, I asked them at what point they had put the court on notice of the structure's separate title status and its value. The answer was that they had not, because they did not know. She said the argument became quieter after that. I said, and the second hearing? She said, the judge is going to hear the motion to reconvey or reopen. I said, what do we expect? She said, we expect the judge to be unhappy. I said, with me? She said, with the situation. A judge who awards a settlement in good faith and then finds that a significant asset was not included because of a classification neither party raised explicitly is not a judge who is going to enjoy the experience. She said, but unhappiness is not recourse. The structure was personal property. The order addressed real property. The classification was correct and documented and had been established before the marriage and maintained throughout. She said, we expect the motion to be denied. She said, we also expect a comment from the bench. She was right on both. The second hearing was on a Tuesday morning in October. I was in the courtroom. Diana was across the room. We had not spoken directly in 4 months. She looked at me once when she came in. I looked back. Whatever was in her expression, I did not try to read. The judge was a woman named Judge Patricia Warren, who had been on the family court bench for 16 years, and who had the specific manner of someone who had seen most of what family court produced, and who had therefore developed the patience to hear everything before responding, and the precision to respond without excess. She let Diana's attorney make the full argument. He argued intent. He argued equity. He argued that the classification distinction was a technicality that should not override the clear purpose of the settlement. Margaret responded. She covered the classification status, the registration date, the fact that the structure's separate title was a matter of public record accessible to any attorney who searched the correct database, the fact that the settlement demand itself had described only the real property, the fact that the court order reflected what the parties had put before it. She said, my client held personal property and exercised his right to dispose of it. The characterization of this as bad faith requires the argument that he was obligated to disclose a separate personal property asset to opposing counsel who had the same access to the registration database and who chose not to search it. Judge Warren listened to both sides. She was quiet for a moment. She said, I am going to say something before I rule, and I want both attorneys to understand that what I am saying is for the record. She said, the purpose of discovery and the purpose of asset disclosure in divorce proceedings is to ensure that both parties have complete information about the marital estate. That purpose was not served in this case, not because either party concealed information in a legally actionable way, but because the requesting party's counsel did not conduct adequate due diligence on the asset they were requesting. She looked at Diana's attorney. She said, "The classification of modular and manufactured structures as personal property separate from real property is established law, a title search of the kind that any prudent attorney would conduct before aggressively pursuing a specific asset in a settlement demand would have revealed the separate registration. It was not conducted. The consequences of that failure are not transferable to the opposing party." She looked at Margaret. She said, "I also want to note for the record that a party who is aware that a specific asset is not what the opposing party believes it to be has, at minimum, an ethical obligation to not actively misrepresent the situation. There was no active misrepresentation here. There was silence about a distinction that opposing counsel should have identified independently." She paused. She said, "The motion to reopen the settlement is denied. The order stands as entered. The real property was awarded and transferred. The personal property disposition was lawful." She looked at both attorneys. She said, "Next case." I drove home from the courthouse. I called my father. He was 78 by then and was in the workshop that was now a retirement hobby rather than a livelihood, but that still smelled of sawdust and linseed oil. He answered the workshop phone on the fourth ring because he was slow getting to it. He said, "Tommy." I said, "It is over." He said, "The hearing." I said, "Yes, the motion was denied." He was quiet for a moment. He said, "The structure." I said, "Yes." He said, "Where is it now?" I said, "On a property in Rutherford County with a couple who are very happy with it." He said, "And the land?" I said, "Watauga County. Diana's name is on the deed." He said, "The view?" I said, "Still there. She has a very good view of the ridge line." He said, "Tommy." I said, "Yes." He said, "I want to tell you something about this." I said, "Tell me." He said, "When you were 14 and you put a nail in wrong, do you remember what I told you?" I said, "Fix it and then do it right." He said, "Yes, but I also told you something about why it mattered." I said, "The nail is in the house for 100 years." He said, "Yes, what you build stays. The way you built that structure, the registration, the title, the modular classification, that was the right way to build it. You built it right. Everything else followed from that." He said, "She wanted the shortcut, the thing without understanding what the thing was." He said, "The nail was in wrong. The judge agreed it was in wrong, but the house still stands." I said, "And now it is standing in Rutherford County." He said, "On a foundation someone else's hands put down." I said, "Yes." He was quiet for a moment. He said, "Come for dinner Sunday." I said, "I will be there." Diana reached out directly once. Not through attorneys. A text message, 4 weeks after the second hearing. It said, "I want to say something to you directly." I replied, "Okay." She called. I answered. She said, "I want to tell you that I know what happened." I said, "Okay." She said, "I do not mean the structure. I mean why you kept it classified the way you kept it." I said, "I kept it classified that way because it was the right way to classify it for a mountain modular structure." She said, "Thomas." I said, "Diana." She said, "I am not accusing you of something. I am telling you that I understand now what I did not understand when my attorney put that property at the top of the list." I said, "What did you not understand?" She said, "I did not understand what it was. I thought it was a house on a hill that had value because it was on a hill. I did not understand that the hill and the house were different things. I did not understand that the house was yours in a way that the hill was not." She said, "I thought I was taking something of yours. I was, but I took the hill, and the hill was always just the hill." I said, "It is a good hill." She said, "The view is magnificent." She said it with the specific quality of someone who had stood in a field of dirt and looked up at a ridge line and understood what they were looking at. I said, "Yes, it is." She said, "Thomas, I want to ask you something." I said, "Ask." She said, "When you built it, when you spent those 3 summers going up there and putting it together, what were you actually building?" I thought about that for a moment. I thought about my grandfather's hands on the wood. I thought about my father saying the nail is in the house for 100 years. I thought about 3 summers on a mountain with specific materials and specific tools and specific standards. I said I was building something I could be proud of, not to show, to know. She said, "I did not understand that about you." I said, "I know." She said, "I thought you were building an asset." I said it was also an asset. Those are not mutually exclusive. She said, "But the asset was secondary." I said, "Yes." She said, "That is what I did not understand." She said, "I thought everything you built was for the outcome." I said, "Everything I build is for the thing itself first. The outcome follows when the thing is built right." She said, "I understand that now." She said, "I am sorry, Thomas." I said, "I know." I said, "Diana, I hope the land serves you well." She said, "It is 5 acres of mountain." I said, "Yes." She said, "I do not know what to do with 5 acres of mountain." I said, "Figure it out. That is what the land asks you to do." She said, "Okay." She said, "Goodbye, Thomas." I said, "Goodbye, Diana." The structure in Rutherford County is doing well. The couple sent me a photograph in the spring of the following year. They had done something I had not expected. They had planted a garden along the south-facing side of the house, in the space where the morning light was best, and the garden was already producing in a way that told me they had planned it carefully and planted at the right time. The kitchen I had installed over a long weekend in the second summer was clearly visible through the window in the photograph. The same cabinets, the same stone countertop. I looked at the photograph for a while. I thought about Lenoir and the cabinet shop and the day the countertop was cut and set. I thought about my grandfather's workshop, about the smell of sawdust and linseed oil, about the tools that tell you the truth. I called my father. He said, "Tommy." I said, "I got a photograph of the structure in Rutherford County." He said, "Send it." I sent it. He called back 10 minutes later. He said, "The garden." I said, "Yes." He said, "That kitchen." I said, "The same one." He was quiet for a moment. He said, "You built something and it is living somewhere, and someone's garden is growing beside it." He said, "That is the whole thing." I said, "Yes." He said, "Do you miss it?" I said, "I miss the view." He said, "The view is still there." I said, "Yes, Diana has the view." He said, "Maybe she will figure out what to do with it." I said, "I told her she would." He said, "What did she say?" I said, "She said she did not know what to do with 5 acres of mountain." He said, "Nobody knows at first. You figure it out." I said, "That is what I told her." He said, "Come Sunday." I said, "I will be there." I am building again. Different land. Not Watauga County, Yancey County, further west and higher up, with a north-facing ridge and a property that I bought the previous spring, and that has been sitting while I decided what to put on it. I decided this spring. Modular again. Different design this time. I have been working with the manufacturer in Lenoir on a layout that takes advantage of the north-facing aspect, and that uses materials that are appropriate for the elevation and the climate. I am registering it correctly from the beginning. Personal property. Separate title from the land. The tools that tell you the truth. The nail goes in right. My father is 78 and still in the workshop. He is not fast anymore. The hands are slower and they know it, and they compensate by being more deliberate. He said last Sunday, when I showed him the plans for the Yancey County structure, "You are using the same cabinet shop." I said yes. He said the same countertop material. I said local stone from a different quarry, different color. He said better or worse. I said different. I want this one to look like itself, not like the other one. He said that is right. He said each thing should look like itself. I said yes. He looked at the plans for a while. He said this is the door placement. He was pointing at a detail. I said yes. He said you have the morning light coming through there. I said south by southeast. He said and the kitchen faces. I said west, evening light for cooking. He put the plans down. He said your grandfather would have approved of the orientation. I said I thought about him when I laid out the plan. He said he was particular about light. I said I know, you told me. He said I think I told you more than you needed to know about your grandfather. I said there was no such thing. He looked at me. He said no, there was not. He handed the plans back. He said build it right. I said that is the plan. He said it is always the plan. I said yes. He went back to his workbench. I rolled up the plans. I drove back to Hickory. I thought about a field in Watauga County with a ridge-line view and the specific morning light that came over the mountain at a particular angle in late September that I had seen 40 times, and that I had tried to capture in the window placement of the structure that was now in Rutherford County, with a garden growing along its south side. Some things you build and they stay. Some things you build and they move. Both are built. Both are real. The field is still there. The view is still there. And somewhere in Rutherford County, the kitchen I built over a long weekend is still the right kitchen for the people who live inside it. That is what building correctly produces. Something that lasts, wherever it ends up. Here is what this story is about. Not the clever legal classification. Not the field of dirt and Diana's face when she arrived. Not the second hearing and the judge's comments from the bench. Those things are the surface of the story. They are real and they happened, and the story would not be complete without them. But the story is about what my grandfather said about tools. The tools that tell you the truth. A power tool does the work fast. It does not tell you if the work was done right. The hand plane tells you. The chisel tells you. The square tells you, because they require you to be present in the work instead of just present at the outcome. I built the structure in Watauga County with the same philosophy. I classified it correctly because correct classification was the classification that fit what I had built. I registered it as personal property because it was personal property. I maintained the separate title because separate titles were right for modular structures that might need to move. All of these decisions were made before any divorce was possible or anticipated. They were made because they were right. And when the situation came where the way I had built mattered in a legal context, the building held. The nail was in right. Everything else followed from that. Diana's attorney had assumed. I had built. Those are two different approaches to the same situation. One produces an award of $160,000 worth of mountain land. The other produces the knowledge that what you build outlasts the circumstance you built it in. The structure is in Rutherford County. The garden is growing. The kitchen is the right kitchen. The view in Watauga County is still there. My father is in the workshop. I am building something in Yancey County. The nail goes in right. That is the whole thing. Thank you for being here for this story all the way to the end. Like this video right now, if the empty field produced the specific feeling you came here for. Subscribe to this channel and ring that notification bell. Every week there is a story here that is real and that goes deeper than the surface. I want you here for all of them. Share this with someone who needs to hear that doing things correctly from the beginning is not just ethical. It is the thing that determines what happens when the circumstances test what you built. Comment below. Tell me what you thought when Diana arrived and the house was gone. And tell me if you have ever built something the right way and had it matter later in a way you did not expect.